Hi everyone, my name is Corley McIver. I'm the Honorary Secretary for Bristol Law Society, and I'm delighted to welcome you all to today's webinar. I'm joined by Julian Borley today, who is a VAT Director at Milsted, Langdon, and he will be talking to us about VAT transfers of going concern and giving us some top tips. Just before I hand over to Julian, I'd just like to remind everyone that we are recording this session so that it will be available for our attendees after the event. And also we will be sharing the slides as well after the event for all the attendees, so there's no need to scribble down any notes that are on the slides, etc. We will be doing a Q&A, so if you have any questions during the talk, please pop your questions into the Q&A box at the bottom, and we will be picking those up at the end together with the pre-submitted questions that people have submitted in advance of the session. I think that's all I have to say. So now I will hand over to Julian to kick us off and talk about VAT. Thank you very much.
Thank you, Coralie. As Coralie mentioned, I'm Julian Borley, the Director of VAT at Milsted Langdon. And I want to talk to you today about transfers of going concerns, or as VAT advisors, we tend to call them TOGCs. And as I'm talking to an audience of lawyers, I want to really focus on how TOGCs relate to land and property transactions. And I hope to give some tips, mainly how to avoid some common pitfalls. So I want to start by talking about what a TOGC actually is. I think there's a common misconception amongst a lot of people that a TOGC is actually a VAT relief that allows assets, including land and property, to be transferred VAT free. And that misconception is perhaps understandable on the basis that that's the spin that an awful lot of HMRC's guidance actually gives it. However, in reality, it's a fraud prevention mechanism. In the old days, what used to happen would be a business would be looking to close down. They would sell the assets of the business, and the person retiring would decide to go off to the Costa del Sol, and they'd suddenly realise they'd collected a whole lot of VAT and think to themselves, well, this would be a good additional nest egg to take with me on my retirement. And effectively, it would be difficult for HMRC to ever catch up with them and collect that VAT. So TOGC rules are actually compulsory. If you meet all of the requirements, then it's a TOGC regardless of whether you want it or not. And in those instances, the transfer of assets are actually seen as neither a supply of goods nor services and are outside the scope of VAT. Now, it's this compulsory nature of a TOGC that perhaps causes the problems. Effectively, if you're the vendor in a sale and you've treated it as a TOGC, if it turns out later that it's not a TOGC, then you owe the VAT to HMRC, and collecting that VAT could prove difficult. Now, of course, the sale and purchase agreements will seek to have clauses to try and solve this particular issue. But even then, there can be problems. It might be that the purchaser argues that not enough has been done to defend the TOGC position. And of course, one of the main elements that's put into a sale and purchase agreement is the fact that the purchaser will pay the VAT if it proves not to be a TOGC, as long as they're provided with a valid VAT invoice. Now, this causes difficulties sometimes for vendors on the basis that if the property has been sold a while ago, then it may well be that they've deregistered for VAT and are no longer in a position to be able to recover VAT. For a purchaser, it's almost the flip side of that situation. If somebody has charged them VAT when in reality the transaction should have been a TOGC, then they'll have difficulty in recovering the VAT. VAT can only be recovered if it's been correctly charged, and that's a double-edged sword as far as VAT is concerned. HMRC can argue that if a vendor has charged VAT incorrectly, they can recover that VAT as a debt to the Crown because it's been described as VAT. But for a purchaser, they are unable to recover that VAT, and so basically HMRC can have their cake and eat it. So not only does it mean that a TOGC, the TOGC mechanism effectively stops people absconding with VAT, but it also pushes the risk on to the purchaser to some extent. Now, I want to talk about some of the basic rules in regards to TOGCs. Effectively, the situation is that as long as 6 or 7 conditions are met, then it's a compulsory TOGC. And I suspect in most land and property transactions, those conditions are taken for granted that they're already met. But I think it's well worth mentioning these conditions because if you're overlooking some of the more basic points, it might be that there are issues with your TOGC that you just don't realise. So the first of the conditions are that the assets that are bought by the purchaser must be used in the same way that the vendor used them. Now, there's been case law which suggests if the assets of an Indian restaurant are transferred and the new owner uses them as an Italian restaurant, then of course those assets are used in the same kind of business. And in those circumstances, the TOGC rules are met. However, I think it's worthwhile considering whether the purchaser is going to change the business in any way afterwards, and potentially taking some advice if that change is going to be significant enough. In terms of property transactions, this condition usually causes problems in regards to occupation. So, for example, in terms of a pub business, if a pub chain has been letting a pub to a landlord who's been operating it as a pub, now wants to sell that particular building, and the purchaser buys it as a pub that they're going to operate themselves as a pub, then there's a different kind of, the assets are being used in a different kind of way. So in the first instance, they're being used as a letting, in a letting business, and in the second, they're being used in the pub retail business. Similar sorts of conditions or considerations apply, perhaps where you've got a manufacturing business that's been operating out of some facilities, and they decide to transfer the property to a pension scheme. The pension scheme intends to let it back to the manufacturing business, and everybody considers that this is just a TOGC because it's being operated in the same way. But in fact, one business is using it for letting and the other is using it as a manufacturing business, and therefore the assets are used in different ways. The next condition is that if the seller is a taxable person, then the purchaser must also be a taxable person. Now, taxable person usually means that they are VAT registered. However, it also means somebody who should be VAT registered because they're above their turnover and haven't registered for VAT. And although that would be unusual, that could cause problems. Effectively, it's wise for the purchaser to already be registered for VAT. And clearly that might mean that they need to register for VAT on an intending basis, and that's something that Milsted Langdon could help out with if you have a client that needs to register for VAT. One point to mention, however, is that when you purchase a business as part of a TOGC, then you actually inherit the taxable turnover of the vendor. And that means that if the vendor is already over the VAT registration threshold, then if you haven't already registered for VAT, then it is going to trigger a VAT registration, but this can cause problems, and in my view, it's better to be registered in advance. In relation to a part transfer, that part must be capable of a separate operation, and that means that if you're selling part of the business, it needs to be able to run on its own. So effectively, if you had one business that had two factories, each was producing a different product, and you were to sell one of those factories, then I would say that would be a transfer of a going concern of a part of a business. Now, the fact that that factory was probably supported by an accounting function and an HR function within the original business shouldn't mean that there's a problem. Basically, if the new owner provides that support function themselves, then in my view, you've got a business that has been transferred. Now, perhaps the most obvious one is that the business being transferred must be a going concern, and that effectively means that a dormant business cannot be transferred. And there must not be a series of consecutive transfers of the business. Now, that means that if there is a series of transfers, then each person that has had that business must operate it as a business. Now, that causes problems in regards to property transfers, where a property is transferred from A to B to C, and B effectively just flips the property on without actually incurring any rental income. In that instance, the TOGC rules would not be met, and it would be seen as a series of consecutive transfers. Now, there must be no significant break in the normal trading pattern immediately before or after the transfer. Now, if, for example, you've got a restaurant, you've bought that restaurant and you think, well, it looks a little bit tired, I'll close it down, refurbish it, repaint it, then in that situation, there is HMRC see that as the normal trading pattern of a business, and I wouldn't see that as a significant break in the way that the business has been transferred. However, you're likely to get questions at some point from a purchaser who really just wants to buy the assets, or certainly long-term wants to buy the assets of the vendor, and effectively says, well, look, if we operate the business for a period of time, then can we treat this as a transfer of a going concern? Now, the question arises in such circumstances, how long do they actually have to operate that business? Would it be a day, a week, or a longer period of time? Now, I don't think you'll get a consistent answer from VAT advisors in regards to this, and I think it will depend on their attitude to risk as to the answer they would give. The reality is that a genuine business must be transferred, and that would need to be supported by the amount of time that the business is run by the new owner. And I think certainly in terms of land and property, where it's a rental business that's being transferred, then certainly you'd be looking at a rental payment period, I think. So, you know, if that's a VAT, a rental quarter that it's operated for before the change in the business activity happens. However, the other factor in regards to this is that it'll depend very much on the attitude of any HMRC officer looking at this as to whether they agree or not that an actual business is still being operated. And therefore, certainly if you're giving advice to your clients in regards to how long the business can be operated afterwards, I think caveats need to be provided that this is something that could certainly be challenged by HMRC. So basically, this really means that the effect of the transfer must be to put the purchaser in possession of a business which can be operated as such. Now, effectively, that means that a genuine business needs to be operated. Now, where land and property is involved in such a transfer, there are usually two circumstances. Usually it's either the premises from which the business is operating, so the factory in the example that I've given a couple of times now could be transferred along with the manufacturing business, or in terms of most buildings, it's actually a rental business that's being transferred. So you're transferring the building with the benefit of a tenant in place. So in VAT terms, it's not necessarily the transfer of the building that's happening, it's the transfer of the rental business that's being sold. Now, in either instance, if VAT, if a property is being transferred, then there are two additional rules that need to be considered in order for the land and property to be included within the transfer of going concern treatment. The first is that if the property is opted to tax in the hands of the vendor, then the purchaser must also opt to tax the property. And indeed, they must notify their decision to opt to tax by what's known as the relevant date. Now, the relevant date is the earlier of either payment, other than a deposit held as stakeholder, or completion in regards to the transaction. Now, the other condition that needs to be met is in regards to the anti-avoidance provisions. The purchaser must tell the vendor, again by the relevant date, the earlier of payment other than deposit held as stakeholder, or completion, that the anti-avoidance provisions that are contained within Article 5.2b of the Special Provisions Order will not apply, and that the option to tax will not be disapplied by virtue of these. Now, this point is usually dealt with in the sale and purchase agreement. So rather than the purchaser physically telling the vendor that the rules are not going to be disapplied, there's usually a clause within the sale and purchase agreement that says they don't apply. And indeed, I would imagine that in very few cases they do apply. The anti-avoidance rules really kick in if the property is being transferred to either a connected party to the vendor, or to somebody who's helped fund the transaction or the acquisition, original acquisition of the property. So if it's a genuine third-party transaction, then it's very unlikely that these anti-avoidance rules are going to kick in. However, I get a feeling that because they're in the sale and purchase agreement, that sometimes these rules are overlooked, and it might be that there are instances that are signed off such that the purchaser is saying that the provisions don't apply, where it just hasn't been considered at all. And so my advice would be that if you know that there's a connected party in terms of the transaction, that further advice is sought. And indeed, I think it's in regards to the option to tax that many of the problems in regards to transfers of going concerns actually arise. Certainly because it's a requirement of the purchaser to opt to tax if the vendor has opted to tax, then usually the purchaser will ask the vendor for sight of HMRC's acknowledgement of the vendor's notification of its decision to opt to tax. And this, I think, is where problems tend to arise. Ironically, it's surprising how many people can't lay their hands on the acknowledgement from HMRC. In many instances, they know they've opted to tax because they've been charging VAT to a tenant for a number of years. And that might mean that even if they haven't actually notified the option to tax in the correct way to HMRC, and therefore don't have an acknowledgement, that they do have what's known as a de facto option to tax. Now, that I think is still going to cause problems. So what usually happens in these circumstances is that the accountant is asked if they can dig out the original notification of the decision to opt to tax. And of course, if they were the original accountant that did that work, or even if the vendor had actually asked the accountant to do this work, then one would hope that it would be easy for the accountant to find this. However, on the basis that the option to tax has usually been made many years in advance and potentially before electronic archiving came in, it might even mean that records need to be looked through in terms of a physical archive to try and find the acknowledgement. Further, it's surprising how many businesses actually don't even know whether they've opted to tax. So, for example, I've come across situations very recently where somebody has said to me, we know that we had a subtenant several years ago. We think we might have charged them VAT, but we can't find our records to say whether we did or not. Would you be able to find out whether we have? Now, the problem, of course, is that if the accountant has got the record of the option to tax, or if HMRC have got the record of the option to tax, then they'll let the business know that that's the case. Where it's less certain that there's an option to tax, then there can be difficulties. And HMRC at the moment are causing all sorts of difficulties in regards to options to tax. They're taking about 120 days to respond to correspondence in regards to queries about options to tax. And to some degree, they feel very vulnerable in this position. The reason they feel vulnerable, all options to tax actually had to be notified to HMRC, so therefore they may not have a record of an option to tax in any case. But perhaps more importantly, they recognise that they were an earlier adopter of electronic filing of records, and that they actually allowed this process to be carried out by some of their more junior members of staff. So these more junior members of staff effectively ransacked the original hard copy files with the thought of scanning any document that was important. Unfortunately, didn't have the experience to know what documents were important, and it ended up shredding an awful lot of data. Now that means that when a business asks have they opted to tax a property, that effectively HMRC, if they don't know for sure, will send out a rather bland letter that will say something along the lines of we have no record of an option to tax, but that does not mean that the property is not opted to tax. Now, if that's taken 120 days to get back to the vendor, that's probably not going to satisfy anybody, and everybody's going to be in exactly the same position as they were at the start of the process. Now, there's probably some positive advice that I could give in regards to this kind of situation. Clearly, the most obvious advice would be to make sure that if you're looking at an option to tax and seeking the actual acknowledgement, that you do so as early as possible in the process to give yourself time to actually contact HMRC if that's necessary. It might be that if we know that there's a de facto option to tax because VAT is being charged for a number of years to a tenant, that actually, rather than writing to HMRC to ask, have you got an option to tax on file, we can write to say something along the lines of, we opted to tax this property but can't lay our hands on the acknowledgement letter. Could you look through your files? If you can't find the relevant acknowledgement, then please treat this as a belated notification of an option to tax. Now, this particular letter needs to be written in quite a careful way, because some of the VAT language that needs to be used is quite difficult, and might mean that HMRC reject the belated notification if it's not dealt with properly. However, it is something that can be done. And along those lines, if you're really urgently needing assistance from HMRC, there is again a form of words that can be used in order to obtain a much quicker response than the usual 120 days. I think we had a response within about a week or so just recently using this. However, this does require the lawyers from the other side in the transaction to provide input and explain exactly why it's important that the records are obtained as soon as possible. Now, it might be that the acknowledgement can be found from HMRC, and it might even be that the original notification to HMRC can be found that sets out exactly what area of land has been opted to tax. Now, this again can cause unexpected problems. It can quite often be the case that the original notification said opt to tax land to the south of Berwick Street. The area on the enclosed plan marked up in red is the area that is opted. The acknowledgement comes back and says something very similar. So the original notification is dug out. And when that notification is found, then the person who has photocopied it in the old days or scanned it in the new days has done so in black and white. And therefore the plan is no longer as current as it could be, or as illuminating as it could be. Now, in such circumstances, if it's not clear what's been opted, then we're back in the circumstance of contacting HMRC to clarify matters. Now, I've already alluded at the start of the webinar that getting the contract right is important in order to protect both the purchaser and the vendor. And certainly there are all sorts of clauses out there, usually pro forma ones, I imagine, that are put into contracts that seek to provide that protection. Now, I would suggest that those are looked at individually in regards to each particular transaction to see whether, in terms of that transaction, they do provide the relevant protection. As an example, I came across a case very recently where somebody had asked for some advice because they were in an ongoing situation, where what had happened was they sold a property as a transfer of a going concern at auction, and effectively they relied on a sort of pro forma sale and purchase agreement to protect themselves in regards to this transaction. Unfortunately, about 4 years, almost 4 years to the day, which was very unfortunate because if it had been any later, HMRC would not have been able to assess. An HMRC officer came out, looked at the transaction and argued that it wasn't a transfer of a going concern. Now, the reason that they made this argument was that they said that the purchaser had not opted to tax by the relevant date, and therefore the TOGC rules did not apply. Now, the sale and purchase agreement provided all sorts of clauses within there. It effectively had the sort of generic one that said that if it proves that the transaction is not a TOGC, that a valid VAT invoice can be issued, and that the purchaser would pay up in those circumstances. However, it also contained clauses that said that in the event of a challenge, the vendor would sufficiently defend the TOGC position, And it also had a clause that said that if sufficient evidence was not provided in regards to the option to tax, that it wasn't a TOGC, and that it was automatically a situation on which VAT should be chargeable. Now, when the HMRC officer raised the assessment, the purchaser made two arguments. The first argument was, and the HMRC officer raised the assessment and justified it to the vendor on the basis that although the vendor had received paperwork that the actual signed form that a notification of an option to tax would be made on, there was no evidence to actually show that that option to tax form had been submitted to HMRC. And indeed, my understanding is that the form had been submitted by the relevant time. It's just that HMRC had asked further questions of the purchaser, and the purchaser had never responded to this line of questioning, with the result that HMRC rejected the option to tax and stated that that therefore the property was not opted, and the officer involved said there was no TOGC. Now, this officer was particularly harsh, I think, in these circumstances, on the basis that certainly the purchaser had stated that they'd made the option by the relevant time. It's just that HMRC themselves had thrown the option to tax out. So the first argument that the purchaser made was that the contract stated that if sufficient evidence was not provided, then VAT should have been charged at the time, and it was not. And therefore, they tried to argue that it was actually the vendor that was in breach of the sale and purchase agreement, rather than themselves with their failing to opt to tax. The next argument they made was that the vendor hadn't sufficiently defended the transfer of going concern treatment. The vendor had appealed against the assessment and had asked for a review by a further officer, but hadn't gone to an alternative dispute resolution. So effectively, the purchaser was using that as a lever to say, well, we don't think we should pay this. Now, as it happens, and certainly once we got involved, we managed to resolve it, and all the parties were amicable in this particular case. However, it does illustrate, in my mind, that getting some of these clauses right in the sale and purchase agreement can be very important. And certainly from the purchaser's viewpoint, one of the aspects in a sale and purchase agreement is the question about whether the property is actually a capital good in the hands of the vendor. And that can be quite important. Basically, if the vendor has either purchased the property, constructed the property, or refurbished the property for a value of £250,000 or more within the last 10 years, then that property will be a capital good in their hands. Now, what that means is that when they consider the recovery of VAT, they need to consider, are they using the property taxably, or are they using it to some extent for a VAT exempt purpose? And if the extent that they use the property for a VAT exempt purpose increases over that 10-year period, then they need to perform calculations, which effectively means that they have to pay back some of the VAT that they originally recovered. Now, in the hands of the purchaser in a transfer of a going concern, that purchaser actually inherits the capital goods scheme calculations of the vendor. Now, that shouldn't be a problem in regards to an opted building, but certainly if there are going to be changes to the way that the property is used, then it might well mean that it triggers a repayment of VAT, but not a repayment of VAT that was recovered by the purchaser, a repayment of the VAT that the vendor had recovered in the past. So certainly making sure that your sale and purchase agreement actually sets out or determines whether it's a capital good in the hands of the vendor is very important if you're acting for the purchaser. So you might come across a situation where a purchaser wants to buy a building and will say to the vendor, we have a tenant that we can put in place for you in order that you can sell this building to us as a transfer of a going concern. Now, that's exactly what happened in the case of the Royal College of Paediatrics, where the college wanted to buy a building, and because of its VAT status would not have been able to recover any VAT charged to it. So they engineered a TOGC by having a tenant in place. Now, in this particular instance, the area that was let in a rather large building in the centre of London was broom closet sized, so it was certainly my understanding. And so HMRC took offence at this particular structure and saw it as an artificial transfer of a going concern, and basically suggested that VAT needed to be charged. Now, I think there are some circumstances where a tenant may well introduce, a purchaser may well introduce a tenant to a vendor, and they might well be very good commercial reasons. It might be that the tenant just needs to be in place as soon as possible, and that everybody realises that the sale process is going to take longer than is required. So I don't think that merely the fact that a tenant is introduced by the purchaser means that it can't be a TOGC treatment. However, I do think that all of the factors that I've mentioned before need to be considered, and that effectively it has to be a genuine business that's being transferred, and that means that, in my opinion, that that certainly the vendor needs to have operated that rental business for a period of time before it's transferred. And certainly, again, if you're in a position that you are advising in regards to a transfer of this nature, then I think some pretty significant caveats need to be provided. So lastly, I come to deregistration. Effectively, when a business no longer has any taxable activities, it's required to deregister for VAT. Now, we're coming across a trend with HMRC more and more, where their deregistration unit will liaise with their option to tax unit to determine whether there are any buildings that have been owned in the past by that business that have been opted to tax. Now, the reason they do this is not for because of transfers of going concerns. It's primarily because when you deregister for VAT, if you've opted to tax a building and you retain that building, then there may be a self-supply charge. Effectively, in such a circumstance, it's likely that you would need to charge yourself VAT on the market rate value of that particular property. And obviously, by looking into this matter, HMRC are able to make some fairly significant assessments of taxpayers. Now, where this comes into in regards to transfer of going concerns is that once the vendor's business is deregistered, they are likely to still get a list of all the properties that they've opted. This was certainly the case in a matter that I assisted with fairly recently, where a father had been operating a company for many years. He had been developing properties, selling them on as transfers of going concerns because they'd been tenanted. And then unfortunately he died, so that his son took on the company. And he effectively sold the remaining properties within that business, and then deregistered for VAT. Now, what then happened was, several weeks later, through the post, he received some correspondence from HMRC with a list of all of the properties that particular company had opted to tax over the years, and a request that HMRC be informed as to what had happened to each of those properties. Now, this caused him a fair degree of panic, on the basis that he'd not been involved with the business up until that point, and had no idea, and he didn't know whether VAT should have been charged or not. He subsequently found that they'd all been sold as transfers of going concerns, wrote back to HMRC to tell them that was the case, at which point the HMRC officer involved trawled through the records of all of the purchasers, and found a number of instances where the purchasers had not opted to tax by the relevant date, and therefore there were not TOGCs, and the company initially received quite a large assessment for VAT, or was certainly threatened with such an assessment. Now, what happened in this particular instance was that the options to tax had been made, not by the relevant date, but pretty close to the relevant date. So HMRC came to the conclusion that actually there had been no loss to the revenue, and I think, to be fair, on the basis that there was a bereavement involved as well, I think HMRC took a fairly lenient approach and decided that they didn't want to proceed with the assessment that they had threatened. However, I think that this example demonstrates that basically, once the deal is done, I suspect many people think that's the end of the matter, but certainly once you deregister, it shows that the TOGC rules and VAT can still have an impact a number of years after the original deal has been made. So that really was all I was going to say today in terms of this talk. But I understand that Coralie may well have some questions for me.
Hi, Julian. Thank you for that talk. Yes, we have a few questions, which I will start running through. But if anyone else has any more questions, feel free to put them in the chat. So the first question I have is, what if the seller cannot produce the VAT registration paperwork, and how is the buyer protected?
Right, well, I guess to some degree that's sort of been covered in what I've said. I think that to some degree, if the vendor has treated it as a transfer of a going concern anyway, then they're not charging the VAT. And really, it's then whether HMRC can challenge that TOGC treatment is not correct. And so that's, I think, where the sale and purchase agreement needs to protect the purchaser. Now, as I say, there are some difficulties with this to some degree, because if this is found several years later that it's not the TOGC, certainly the vendor is going to have problems issuing the VAT invoice, and I guess to some degree that's where the protection for the purchaser lies, that the sale and purchase agreement should have a clause that says, in the event that HMRC successfully challenged that it's not a TOGC, that we will pay, but on production of a valid VAT invoice. In terms of the VAT registration, whether the questioner really means the VAT registration itself or the option to tax acknowledgement, I don't know. Certainly it would be unusual that the vendor wouldn't be able to provide a VAT registration number or be able to get a certificate of registration from their online account. So I suspect they probably mean the option to tax, and of course we went into that in some detail. But I suspect in that instance, in order to generate the TOGC treatment, the purchaser also has to have opted to tax. So to some degree that mitigates the risk. Whether there's another factor that the purchaser has opted to tax unnecessarily, and whether there is another element of challenge for the vendor in that respect is another matter, I guess. But certainly in terms of the VAT charged, as long as the sale and purchase agreement says the right things, the purchaser should be protected, I think.
Thanks, Julian. Next question is, can the acceptance of the surrender of a lease be a TOGC?
That is a very good question, I would say. Yeah, certainly. I'd probably want to consider that one a little bit more, I think, and potentially if the details of the person are there, I can come back to them. I would imagine, because it's really got to be the transfer of a business in order for it to be a TOGC. So in regards to the surrender of a lease, my feeling is that in such a circumstance, it's effectively there's an interest coming back to the freeholder in that instance. So I don't know whether the person asking the question, whether there is some tenant involved that goes back in that circumstance or not, but it might be worth finding out a little bit more there, I think.
Okay, thanks, Julian. And then next question is, how far back can HMRC go on the deregistration and look at older transactions?
Well, basically, in terms of the older transactions, in the example that I was giving, the information they asked was effectively for all of the businesses that had been opted to tax. But that, I think, was because HMRC had no idea what had happened and they were just trawling for information. In reality, in terms of the transfer of going concern, the decision that's made there that it's treated as a transfer of going concern, if that has been made in error, then HMRC should only be able to go back 4 years in order to deal with that, which is why in the other example I gave, it was problematic that the officer managed to turn up almost weeks before that deadline. But yeah, in terms of the actual TOGC treatment, I think they would only go back the 4 years.
Thanks, Julian. That's all the questions I've got in the Q&A, unless anyone wants to submit another question. I think that's all. So thank you very much, Julian, for speaking to us today. Really interesting. I learned quite a lot, I think, in this, and I'm sure the other attendees did as well. So I can't see any more questions coming through. So in that case, I will draw us to a close. Thank you very much, everyone.
Thank you. Cheers.